of the quarter of this week. Today we have Professor Josh Blackman joining us from the South Texas College of Law. He is the founder and president of the Harlan Institute, and he created Fantasy SCOTUS. And today he's going to be talking to us about 3D printed guns and constitutional arguments surrounding their existence.
Thank you. Thank you so much. And also thank you to Judge McConnell, who was kind enough to offer some comments afterwards. I'm grateful to Stanford for hosting me. So we have a treat for you today. Not one constitutional right, but two constitutional rights. And my goal is to discuss how 3D printed guns implicate both the First and the Second Amendments. And you can disclose at the outset, this started as an academic pursuit for me. I started actually writing a paper about 3D printed guns. And after I published the paper, a guy named Cody Wilson contacted me. Cody is the creator of the Liberator, and he said, I want to hire you. So lest you think academics never do anything practical, I actually got a job out of a paper I wrote, and I published an article. So I'm actually counsel for the 3D printed gun litigation. We are currently on appeal to the Fifth Circuit. I'll get more to this later. But this is actually a real life case, unlike a abstract historical inquiry. So first I want to discuss 3D printing. Has anyone ever actually used a 3D printer? Oh, come on, Stanford. 2 people? Wow, this is disappointing. Okay, 3, 4, whatever, okay? So what is 3D printing? The same way you can draw an object on a piece of paper, you can draw an object on a computer. On a piece of paper, there are 2 dimensions. On a computer, there are 3 dimensions. And you can design any manner of interactive shapes and sizes, everything from a house to a car, or anything in between. And the process of designing something in 3D is actually fairly straightforward. It involves basic principles of geometry. So I'll make you force back and remember your high school geometry. Does everyone remember the formula for the volume of a cylinder? Pi r squared times height. Does that sound familiar? Okay, so if you want to have a cylinder, you create height of 20, radius of 5. And you can say with those units, you can figure out how big a cylinder is. That's it, right? You're using words that a plain people can understand. It took me 3 seconds to explain to everyone in this room. This is how 3D printing works. And you can create any manner of objects from simple, trinkets to more complicated objects, even to you can see here, a race car. And this is what a 3D printer looks like. A 3D printer uses very fine layers of plastic to create an object of varying degrees of complexity. So the way I explained how 3D printer works is like making a candle. Has anyone ever made a candle before? You take the wick and you dip it in the wax, and you dip it in the wax, and you keep dipping it over and over again, right? 3D printing works the same way. But instead of dipping something into wax, there's a little nozzle. And it sprays a very fine layer of plastic. And it puts one layer on top of the other, on top of the other, on top of the other, until you make a full object. This diagram explains it well. You have here a little platform. You spray plastic and it lifts up. You spray plastic and it lifts up. It keeps moving up and up and up as the object gets bigger. So I'm going to show you a series of shots of something being printed on a 3D printer. When you see what is being printed, I want you to scream it out. You'll see it, but the trick is how quickly do you see it, okay? So stage 1. The 3D printer spits out this little honeycomb lattice, like a honeycomb a framework of an object, okay? Frame 2 gets a little bit thicker, right? Frame 3 gets a little thicker, and you can see a shape is actually starting to take form. Number 4, when you say it, scream it out. Number 5. Whoa! Who said that? Winner. I've never had this early. Usually they get it here, but never had it here. That's a prize. He gets a free pizza, right? 6, 7. Everyone see it now? You should get Frog. People get Frog. Are you a Star Wars fan? Yeah, figured. So the Force Awakens in this young one, right? 6, 7, 8, 9. You see it now, right? 10, 11, 12, 13, 14, and done he is, right? So we got that one. So in the matter of about maybe 10 or 15 minutes, you can use this 3D printer to create a very intricate sculpture. Now, I can't sculpt, maybe you guys can, but I can write code. So it actually allows me to create something with code that I could never sculpt out of plastic or stone or clay. I have no talent. I'm very artistically challenged, but I could probably figure out how to design this on a computer with Photoshop. You can create very intricate designs with interlocking parts and gears. Really, the sky is the limit as to what you can create with a 3D printer. So, California, what do you think the first thing that people wanted to design with a 3D printer was? Come on. What would be the first thing people want to design with a 3D printer? Are we in America? Guns! Yes! Oh, I love California. I do this talk across... Thank you, Judge. I do this talk across the country. When I do this in Alabama, the hands went right up. When I do this in New York, it's like, what's a gun, right? What's this gun? Yes, so almost immediately after 3D printing became a viable technology, you can go to Best Buy and purchase a 3D printer for about $2,000, professional grade. These are not that expensive devices. People started designing 3D guns, okay? And one of the first such devices was something known as the Liberator. Now, I should disclose, the Liberator, here's a picture of one of the parts in 3D rendering, was designed by this guy, my boss. So I'll be very nice about him. This is Cody Wilson. Cody was a first-year law student at the University of Texas. He never quite finished. During his 1L year, he designed the Liberator. And he found a way to make 3D gun parts work. One of his first inventions was this. Come on, California. Does anyone know what this is? Yes, it's what? Say it. This is an AR-15 lower receiver, okay? This is basically the guts that make an AR-15 work. What's interesting is this part, if you create it by yourself, does not need a serial number under federal law. Under California law, it does, but under federal law, you can make this yourself, and it's perfectly lawful. Cody managed to make the AR-15 receiver entirely out of plastic, okay? One of the other things that Cody created was this. It's a magazine for an AR-15. Again, I'm in California, so I'll explain. A magazine is what you put bullets into, right? It's that chamber that you load bullets into that fires. He named the magazine the Cuomo after the governor of New York, who tried to ban these, only to realize that basically you can't buy a gun without these things. So anyway, but up to this point, Cody was kind of making a name for himself. But then he built this. What the heck is this, right? What are these strewn out parts? These are the elements of the Liberator. These are the parts that, when assembled correctly, can make a fully functional pistol, a handgun. And you can see some of the aspects here. This is what it looks like when it's fully assembled. Here was the finished product. It looks ghastly, right? It's basically this blue handle with this white, big thing. How is this even a gun? Well, very simply, how a gun works, you only need two things, really. A bullet and a firing pin. So how does a bullet work? In the back of a bullet, there's a little bit of charge, gunpowder. If you strike the gunpowder, it creates an explosion. The explosion then sends the projectile forward. That's how a gun works. So the purpose of this is to pull a trigger, there's a roofing nail, strikes the back of the bullet, and sends it forward. Okay? Cody did quite a number of tests, as you can imagine. Before he put his finger on this to pull the trigger, it blew up a lot, so he had a lot of tests. What he actually was tie a string to the trigger and send it very far away and yank it. But eventually he was able to treat the barrel with enough acetone and vinegar to make it strong enough that he actually did a test, and it worked. Cody put the blueprints for the Liberator on the internet, and I forget the exact numbers, but within 24 hours it was downloaded hundreds of thousands of times. I mean, this one totally viral. Everyone was downloading this file, saying, okay, now we can do this. Now, is there a problem with what Cody did? And again, I'm his attorney, I'll be charitable, but is there a problem with what he did? So the first rumor that I wanted to dispel, this is not how 3D printed guns work, right? You don't just print a button and like a fully functional handgun pops out. This is what people have in their minds. This is not accurate. What actually happens is that you have to print these 18 separate parts. They're actually fairly complicated to assemble, very expensive to assemble. You have to treat the barrel in acetone and vinegar. There's a very lengthy process, right? So this isn't just click, print, shoot. There's stuff that goes on before this. There's actually skill involved. The second point I want to make, and this may be foreign again to people in California, is that people have been making their own guns for a very, very long time. So who knows what a zip gun is? Shaking your head. What's a zip gun?
It's kind of just like a tiny pipe arrangement that allows you to fire a bullet.
Yeah, right. To fire a gun, to fire a bullet, all you need is a pin and a bullet and a tube. It's actually fairly straightforward. Okay? What is this? I can go to Home Depot right now, and for $10 in parts, I can buy the parts needed for a gun. This is a garden hose and a soldering iron. A gun. You don't need much more than this, right? You don't need a $2,000 3D printer to make a one-shot gun. You know, there's a little keychain flashlights you can buy at, at the CVS for $5. It's a gun. You basically put a bolt in the end and you jam it. Okay. Now I want to show you a demonstration. Do not try this at home. The people in this video are idiots, but they're useful idiots, okay? This guy is going to build, with his flip phone from like 1997, right? This guy is going to build a rifle out of a piece of pipe, rubber tubing, and a shotgun shell. 3 parts. So what does he do? At the end of this metal pipe is a little dimple. If you slam that metal pipe against a shotgun cartridge, it goes boom. Right? That's how a shotgun works. So Mr. Genius here loads, you'll see why I'm making fun of him in a second. He loads this shotgun shell into the tube, and what's he going to do? He's going to jam this pipe into the back of the bullet. You can see here the little firing pin range. Now, does anyone see a problem based on the room he's in? Anyone notice it? No. What do you see in the background? Outlets. He's firing at electrical outlets. There are wires coming down here. There's more wires there. And you can see if he's done this before, there are about 4 or 5 holes in this box. Okay? Okay, so what's he do? He lines up. And in case there's actually a fan spinning as he's doing this. These guys are morons, but I promise you, there's a reason why I'm showing you this. I promise. There's a reason. You can see 5 or 6 bullet shells. So what happens next? Ready? Boom. Boom. Okay? You can actually see, if you pay attention, another hole just opened up on the box. He fired about 6 inches short of an electrical outlet. I mean, these guys are idiots. And look how proud he is, right? Yeah, he has the, you can see the smoke wafting out of a shot, and the cartridge is spent. So why am I showing you these pictures? Did this guy break any laws? And let's assume he's not in California. I don't even want to know what your laws are like. But in a normal state, right? In a free state, in Texas where I live, where, I'm not from Texas, but I got there as quickly as I could, as Daniel Boone said. So, actually he said, you sir, go to hell, I will go to Texas. That's my favorite quote. So, did he break any laws? Did he break any laws? The answer is no. Believe it or not, our good friends at the Bureau of Alcohol, Tobacco, and Firearms, our convenience store of choice, right? They've basically said if you're making a firearm for your own use, there's no registration requirements. If it's automatic, slightly different story, but if a single shot weapon, a semi-automatic weapon, for your own usage, it's perfectly lawful, right? California makes you register. We're not talking about California, federal law, okay? So what happens, right? So then how is what my client, Cody Wilson, did, problematic? Why are we in federal court, right? Why am I suing the government for what they did to Cody? So there are 2 main constitutional arguments to discuss. First Amendment and Second Amendment. I will begin first with the First Amendment. So the Supreme Court has said over the last 50 years or so, the idea of a prior restraint of speech is unconstitutional. The government cannot require you to get some sort of permission before you engage in speech, right? This is black letter 1L constitutional law. But wait a minute, you say, Josh, wait a minute, but this is really dangerous speech, right? What if someone downloads these blueprints and makes a gun and does something really, really evil with it, right? So there's something called crime facilitating speech. Actually, Eugene Volokh published an article in the Stanford Law Review about 10 years ago on this exact topic. The mere fact that speech can be used to facilitate crime does not make it unprotected. And I'll give you an easy example. The Anarchist Cookbook. Everyone know about this book? God, and now I'm near Berkeley. I gave this talk in Berkeley yesterday, perhaps more fitting. But people like the Weather Underground, otherwise. In the 60s, they had this book, and this book told you to do some really dangerous stuff: how to make pipe bombs, how to use chemical gas, how to take hostages, like really, really community organizer style tasks, right? There's a lot of dangerous stuff in here. And for years, governments tried to keep this book off the shelves. There was no Amazon, right? So if you keep a book off a bookshelf, you can't buy it. And the courts consistently held, no, the mere fact that a book can be used to teach you something dangerous does not mean you can have a censorship mode. And this is, I think this is the correct rule of law. Maybe you'll disagree, but this is the rule of law. But how do we go then from a book to computer code? And the proposition I'd like to advance is that information is speech. I showed you that code at the outset had to describe a cylinder. This is the radius, this is the height. I did that deliberately to show you that you can use words which human beings understand to describe the objects, and this is not something new. And the Supreme Court has effectively recognized this idea generally speaking, not specifically. In a case called Sorrell v. IMS Health from 2011, about 4 or 5 years ago, this was a Justice Kennedy opinion. He said that, quote, the creation and dissemination of information are speech. So creating information and sharing it, and we're talking about data here, we're not talking about a book, is protected by the First Amendment. I mean, much of what we do and much of the world we live in is designed in code. So I think eventually the courts are going to have to hold, one way or the other, that code in some respects that's expressive is protected by the First Amendment. The Supreme Court has not gone there yet. They're going to have to soon. I can talk about it during Q&A how, but this issue will come up eventually. The second issue, and the Second Amendment, fittingly, it discusses the right to bear arms. It says a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. So what does this right mean? Well, in 2008, the court had a case involving this guy, Dick Heller. I should also note my co-counsel is Alan Gura, who argued Heller. So we have some really good firepower on our legal team. In 2008, the court said that the District of Columbia cannot ban handguns. And then about 2 years later, in McDonald v. City of Chicago, the court extended this ruling to the states. They incorporated the Second Amendment. So as it stands now, the government cannot ban personal ownership of firearms. And here's this great picture of Dick Heller and Otis McDonald. McDonald died about a year ago, but he's a really good man and civil rights icon no one will ever remember, but I'll do my part to keep his memory alive. So the court has not taken a single Second Amendment case since McDonald, much to my own consternation, but they haven't. So I'm going to advance two ideas about how I think the Second Amendment should be understood. You can agree with me or not, but let me make my argument. The first proposition I'd like to advance is that the Second Amendment embraces a right to acquire arms, right? A right to actually get a handgun. I am not saying that there can be no regulations on acquiring it. I'm simply saying that the activity cannot be banned altogether. Because think about it this way, right? Dick Heller actually had a gun in his house all those years, believe it or not. Under DC law, he was required to keep his gun locked up at all times. The second he unlocked his gun, he committed a felony. This is the crazy part. Even if a felon broke into his house and was about to kill him, if he unlocked his gun, there was no self-defense exception. Walter Dellinger struggled with that question from the Chief Justice during arguments in Heller. But after the decision in Heller, he was now able to go to the store and buy a handgun. So the idea of actually bearing arms has a prerequisite. You have to get the gun somewhere, right? You have to be able to acquire the gun somewhere. So the Second Amendment, I think, at a minimum embraces the right to acquire arms, subject to some regulation, but you can actually acquire it. The second proposition that I'd like to advance is that you have a right to make your own arms. And I think historically, as an originalist, this is actually a much more grounded right. At the time of the American founding, when we had our Second Amendment ratified, there was no Cabela's, you probably know what that is. There was no place to go buy guns, right? There was no gun stores in Concord and Lexington, right? There were no gun stores on Bunker Hill. If you wanted a gun, you basically had to make it yourself. And there's this great movie. You ever see the John Adams miniseries? It's based on it's a great miniseries based on the book by McConnell, where Abigail Adams is pouring lead balls and making musket balls, right? This is in our DNA. I realize in California, but in Texas especially, making guns for self-defense and protection of your own person is deeply rooted in many ways. So I think this is actually a fairly historical argument that you have a right to make your own arms. And in fact, in our Fifth Circuit case, we have an amicus brief on this exact point, discussing how basically everyone made their own guns at the time of the Second Amendment's ratification. So why am I saying this? Right? What's the relevance here? So I think we have a case where both the First and the Second Amendment reinforce each other. In a case that maybe not everyone's room likes, in Point Division versus Smith, the court addressed the idea of a First Amendment hybrid right. Make up an example, easy one. The government passed a law saying you cannot wish anyone Merry Christmas. You cannot say Merry Christmas, right? This is Sarah Palin's worst nightmare. Is that a violation of free speech or free exercise? Both, right? They reinforce each other. So here, if you think about it, what's the government trying to do? They're trying to stop people from speaking about the Second Amendment. They're trying to stop Cody from putting information available about how to make a gun. We use an example in our brief of what happened if you're an Olympic target shooter. You're an Olympic target shooter, right? And you want to put on the internet instructions of how to make a very precise scope for a rifle, right? You're a target shooter, and you figure out a different way of making the scope to get more accuracy. You're trying to communicate to others how to shoot a gun. Could the government really say you can't do that because that's perhaps aiding terrorism, whatever else? I think that's an absurd argument, but effectively that's what we have here. Now, what laws currently exist on the books discussing 3D guns? The first conceivable law is something called the Undetectable Firearms Act of 1988. This law was passed, and what it basically says is that all guns must have a certain quantity of metal in them. Just enough metal to trigger a metal detector at an airport, right? It's not a big amount, but it's just enough to trigger the detector. This law was passed in the 1980s following the introduction of the Glock handgun. Everyone know what a Glock handgun is? California. A Glock handgun was a very popular gun, one of those high-selling guns. And what made it famous was John McClane in the greatest Christmas movie ever, Die Hard. No? Oh, wow, crashed. It was Bruce Willis's character in a Die Hard movie used or discussed one of these Glock handguns, and people started freaking out, saying, "Oh my God, we have these plastic guns. We have to do something about them. We have to be able to ban these guns." If I get my slide back up, I can read it to you. My computer crashed yesterday at Berkeley, so it must be a California thing. I don't know. Okay, so dead air. I promise, it's worth the wait. Okay. Here it is. I promise this one's worth it. So Bruce Willis goes, I don't have nearly ambition or swag of Bruce Willis, but he says, luggage, that punk pulled the Glock 7 on me. You know what that is? It's a porcelain gun made in Germany. It doesn't show up on your airport X-ray machines, and it costs more than what you make in a month. This line freaked the heck out of Congress and made them actually pass a law. The only problem is everything Bruce Willis said was false, okay? Everything. There's no such thing as a Glock 7. It's not made of porcelain, it's made of metal. It's made in Austria, not in Germany. It will show up in an X-ray machine, and they're actually fairly affordable guns, right? So everything he said was wrong. But politicians watch movies and, oh man, we gotta, I mean, this came out in 1988. I mean, we gotta ban this gun. So we can thank Bruce Willis for the Undetectable Firearms Act or whatever else it is. But what about actually banning these new 3D printed guns? So shortly, Cody has this picture on his wall. Shortly after, I'm kidding. Shortly after the Liberator was announced, Senator Schumer found a microphone. Didn't take that long, and he proposed we need to ban these guns. He had an entire effort to ban them. That went absolutely nowhere in Congress because Congress doesn't pass laws anymore. We just have pens and phones. So fortunately, nothing happened from that. But there are several proposals of how we could actually regulate 3D printed guns, and there are varying degrees of validity. So one proposal that's actually fairly crazy that I've heard is that we need to ban plastic. We need to ban the materials used in a 3D printer. That way people can't make guns. Okay, so this is asinine because first of all, a lot of people make lawful items 3D printers. This is very stupid. Second of all, you can 3D print a metal gun. So there's a lab in Austin I actually visited. This is a 1911 handgun made of stainless steel on a 3D printer. You can basically grind up metal the same way you grind up plastic and spray this. He said it took him about 40 hours and about $40,000. But as a proof of concept, you make a fully functional handgun, mass steel with a 3D printer. So good luck banning plastic, right? Good luck with that. Another proposal I heard, which is even more insane, is to ban gunpowder, because if people can't use gunpowder, they can't make guns. Yeah, that's not going anywhere. Sorry. California may try to put a tax on bullets, but they're not banning gunpowder. The more attractive method of regulating 3D printed guns involves IP law. And this actually, I think, is perhaps the most pernicious one. Let me explain why. You'll recall back in the day when CDs first came out, that's something called DRM, on digital rights management, where you could actually not load music from a CD onto your computer. Similarly, when you first started using the iTunes bookstore, I'm sorry, the iTunes music store, you didn't actually buy the song. You actually had a license to it, which can be revoked at any time, right? You don't actually own the music, which is surprising to most people, but it's not your library. Same for the Amazon Kindle. Now, the most chilling example of this, and this is almost too good to be true, if you had bought the book 1984, George Orwell's 1984 on your Kindle, one day you woke up and it was deleted from your Kindle. Why? Because Amazon and the publisher had a dispute. So what did Amazon do? They deleted the book from your device. Creepy, right? But you don't actually own the stuff you got on your Kindle. You don't. It's a license. It's temporary. It can be revoked at the will. So what about 3D printing? Okay, 3D printing is perhaps the greatest existential threat to manufacturing. Why? If I can 3D print a pair of $400 LeBron James sneakers for like $5 material, why would I wait online to buy a pair of $400 LeBron James sneakers? Okay, so here's where IP and fashion intersects with guns. There's a concept in economics, and I'm a George Mason graduate, called the Bootlegger and Baptist theory. Do you know about this? Yeah, what's the Bootlegger and Baptist theory?
I don't know. I know it's the notion. It's the notion that.
I love the Ivy League. Yeah.
It's the notion, right? That the problem that if you allow people to make, it's just the idea that if you allow people to make something,
no,
it's going to countercut.
Yeah.
I think it's the idea that you can have strange bedfellows.
Yeah.
Working on regulation.
Strange bedfellows. I like the way you phrase it. I'm going to steal that later. So the perfect example is prohibition, right? Who are the people pushing for the 18th Amendment, right? The prohibition of alcohol. On the one hand, you have the Baptists, right? The people out of religion and morality. We need to get rid of alcohol. No alcohol that touch these. No lips that touch alcohol touch our lips. You've seen the commercials, right? We need to get rid of booze. Who else likes prohibition? The bootlegger. Why? Because they can jack up monopoly rents if they're the only people in town. And there's actually a manifestation of this today, right? If you go to any dry county, they don't have these here, but in Texas they have dry counties where there's no alcohol for sale. On the border of that dry county, there's a liquor store on the other side of the border. Who is keeping that alcohol law in place? The other border town. They want a monopoly rent on their booze. So how does this fit in? By the way, before I move on, less than go 5 minutes without talking about Kanye West. He actually, on a show, said that he's afraid of 3D printing because they can destroy the textile industry. And, for once, he's right about something. But what is the Baptist and Bootlegger coalition, right? So on the one hand, you have, the kind-hearted, Michael Bloomberg, Every Town for Gun Safety, Brady campaign, whatever they're called, right? All the people say we need to save the children. We have to get rid of these dangerous guns. Okay, who are the bootleggers? Kanye, right? Because they don't want people to be able to print whatever they want. So imagine this. Imagine one day you take out your 3D printer and you try to print a gun. And it flashes a message saying, no, you can't do this. Wait a minute. So has anyone ever tried making a copy of a $100 bill using a copy machine, high quality one? Has anyone ever tried? No, well, you guys are honest. Wow, New York last week, everyone tried. If you try, if you go to a Xerox or a Canon high quality, it won't let you. It'll actually spit an error message saying Treasury won't let us do this. The government, it's not quite censorship, but the government has basically installed filters on copy machines. They will not make reproductions of currency. Serious, this has been out forever, right? Same principles here. The government can say, hey, 3D printer manufacturer, we want you to put our little filter that says you can't print a gun. Oh, and by the way, here's an entire list of patents from Nike of things you can't print either. Ah, And that's where the bootleggers come to play. So I see this as actually a legitimate threat of a foothold for the manufacturers to interject themselves and prohibit creation of stuff like, you can't print a gun or Nike sneakers, right? I see that's possible. I'll take questions afterwards, I promise. The final method, and this is actually why I'm in court with Cody, is using export control law. So there's something called the ITAR, the International Traffic in Arms Regulations, okay? ITAR is a method of stopping the United States from, stopping private companies from sending weapons abroad. This was a Cold War era statute passed. It makes sense, right? So during the Cold War, they said, you can't send a Stinger missile to Afghanistan. Okay, yeah, I get that, right? You can't send a tank to Cuba, right? I get that, right? That makes sense. But during the 1970s and 80s, the State Department and Commerce Department started to actually expand the scope of their creep. They expanded their mission. And they said, well, this doesn't just apply to arms, it also applies to technical data. And technical data includes speech. Now, I have a friend in the room. There was actually an OLC memo from a guy named Ted Olson, I'm sure you all know, from the 1980s, where Ted Olson told the State Department as the OLC counsel, you can't do this, right? You cannot apply a prior restraint to speech. You cannot say, right, if you want to ship a missile, that's fine. But if you want to ship a book describing how to do something, there's first kind of problems there. So you had the Carter Justice Department saying you can't do this. You had the Reagan Justice Department saying they can't do this. And so for 30 years, basically they took the position that, okay, we're not going to impose a registration requirement for speech. But then in the 90s, a guy named Bernstein tried to export code, cryptography code, which again, I think is speech. A federal court in California ruled in his favor. The Ninth Circuit affirmed. It went en banc. And before the case went en banc, they vacated it, right? They basically, the government did something to moot the case. They basically transferred it from one department to another. They mooted the case, and they never prosecuted the guy. So basically ended it. But at least the Ninth Circuit panel, not saying much, but Ninth Circuit panel said that you have a constitutional right to engage in the speech. So after that case, there was no action taken by the federal government to enforce the pre-registration requirement on speech until May of 2013. The US State Department sent a letter to Cody Wilson, my client. And they said, hey, Mr. Wilson, we noticed you put some files on the internet. Did you know that you're violating international arms control law? Think about that. You put a file on the internet and the government said you are violating arms control law. They said, here, you put a Liberator pistol on the internet. Now let me stop there for a second. How do you put a gun on the internet? Right? You jam it into your router, you jam it into your USB drive. They didn't put a gun on the internet, they put a file on the internet. But if you read their thing, by the way, we are in California. One of Cody's other creative things is called a Dirty Diane, after Diane Feinstein. It's a silencer, which way he thinks a Feinstein. So, but the key, I'm almost done. Michael's getting antsy, right? The key portion is at the end of the letter, they said, this data should be removed immediately. That's a prior restraint to speech, right? They told him to take down speech. We filed suit in federal district court in Austin in May. The federal district court denied our preliminary injunction. We are on appeal to the Fifth Circuit. We filed the opening briefs. The government's brief is due next month. And we should have arguments maybe in April or May, depending how the Fifth Circuit gets around to it. I hope to be victorious. I hope to win this case. Hope to get attorney's fees, which is always fun. But more importantly, we want to vindicate the Constitution. I thank you all for your attention. I welcome my good friend Michael McConnell for comments, and we'll take some questions afterwards. Thank you so much.
Well, it's a pleasure to welcome Josh back to Stanford. He's been quite a phenomenon at South Texas since you started there, what, 4 or 5 years ago? He's written a leading book on Obamacare. He's been writing a series of articles on the Texas immigration case. I didn't even know he was into the 3D printing, Second Amendment, First Amendment thing. You learn something new every day, which is it's a good thing too, since I know nothing about the subject I'm about to comment on. I have all kinds of it's great to have somebody who knows the technology here. So, I'd like to know, can I get instructions for producing an AK-47 on my own homebrewed email system. And if the FBI is coming asking about that, can I wipe the server clean, maybe with a cloth?
Well, what's interesting, what's interesting, Michael, is the way you framed the question. Even if it's sent by email from a U.S. person to a U.S. person, it's almost invariably routed to foreign servers. So unless you have a server, let's say it's in Chappaqua, New York, right, and there are files being routed, they invariably probably left the country and came back. So the short answer is you'd be violating international arms control law to email those files.
Well, I don't know if that's a relief or not. So I know a fair amount about the First Amendment, a little less about the Second Amendment, a little less than that about guns, and nothing about 3D printing. And I'm making these comments on the fly, but here are just two observations about the constitutional arguments. First question is this really speech? Undoubtedly, it is the dissemination of code, which imparts information, and thus, but not, it does seem to me under modern doctrine, not everything that comes out of your mouth in the form of words or is actually speech. Just as there are some bits of conduct which are speech, burning a flag, right? There are some things which are actually words coming out of your mouth that are not speech. I think the easiest example of this would be something like, let's imagine we are concocting a bank heist, and my job is to tell the driver when to drive up and pick up the bad guys. You know, this requires a split-second thing, and we're in the midst of a bunch of people, so I don't want to go up to Josh and say, hey, driver, go pick up the bad guys at the bank, because everybody will hear. And so our prearranged signal is Barack Obama is the greatest president we've ever had. Protected speech, opinion, right? In fact, if I tell him Barack Obama is the worst president we've ever had, I haven't committed a crime. It's actually viewpoint discrimination. You know? So I go up to him and I say, Barack Obama is the greatest president we ever had, and he drives off and picks up the bank heist people. My words are not speech, but my words are as a form of conduct, which is part of committing a crime, right? And again, I haven't given this a lot of thought, but I have the sneaking suspicion that if the gun which is being printed is illegal, that sending the code is actually not going to be classified as speech, but it's going to be understood as a form of manufacturing that happens to be in the form of words but doesn't obtain protected status. Now, I don't know the law behind any of these things, and you suggested that some of these things are not illegal. And so if the thing itself is not illegal, you may actually have a pretty good First Amendment argument that the government can't make it illegal if done by speech, if it's not illegal when done by other methods. So that might be a pretty good argument.
Yeah, and I could interject. The gun Cody produced is a handgun. Under Heller, that's a quintessential weapon for self-defense. So in that sense, the Second Amendment claim reinforces our First Amendment claim. He wasn't putting blueprints for a machine gun or something that's illegal. The handgun would be perfectly legal to me if you're in use.
It's not obvious to me that just because people have, this is a Second Amendment question now, and this really leads to the second issue, which is there are rights to speak. There are also rights to publish, that's the Free Press Clause, and there's the right to keep and bear arms. The exact contours of that right are not so clear. But conduct which is directed at, which is preparatory to speaking, or preparatory to publishing, or preparatory to keeping, I would think by analogy, keeping and bearing arms, is not necessarily protected. Just because you were doing something in order to speak about it, or in order to generate information about it, doesn't make it protected. That quote that was up there, was that Justice Kennedy? and I didn't recognize the quote, besides being, I think, ungrammatical. I also think it's wrong that what the quote was the act of creating or publishing
And disseminating.
is speech, or disseminating. Disseminating is indeed speech. It's either speech or press. But creating information is not speech or press. And you do not have a freestanding right to create whatever information, at least not under the Free Press Clause. And it seems to me, similarly, it's not obvious that these preparatory things to keeping and bearing arms are going to be protected under the second either. I'm going to sit down because they would really rather ask you questions than hear my off-the-cuff.
Thank you. I'm very grateful to have Judge McConnell offer these kind comments. I'll start questions, then I'll talk more later, but I can maybe use your questions to branch off and respond to Michael's things. I think your hand was up first.
Yeah, my question involves something I know very little about, which is the patentability of guns.
Mm-hmm.
So what I imagine is going to happen is 3D printing is going to get very good. And as I understand it, there is some element of intellectual property with specific types of guns. I don't know how specific you have to get. I don't know if AR-15 itself would be patented for a specific modification to an AR-15. But my question is that would enforcing those patent laws have not just First Amendment implications, but Second Amendment implications if those patent laws were what were being enforced when you were printing off the gun? So if they were saying, no, it's not that you can't print off the guns, you can't print off anything patented.
Right.
Therefore, which covers essentially, as I would understand, a huge amount of what we would think of as modern handguns.
Right. So very good answer. I'll get to the question in a second. So the first response that Cody built his gun to be open sourced. Actually, it's Cody's ethos. I mean, he reads Bastiat like we drink water, right? His ethos is freedom. He believes in it deeply, and he made his gun open source. Had he simply ripped off a Glock handgun, rather than the State Department sending the letter to him, Glock would have filed for a TRO to stop his production, and he would have won. So I don't think that there's a Second Amendment right to make whatever gun you want, even if it's patented. And in fact, Larry Lessig, who's no longer running for president, he tried to argue about the First Amendment and patents. He didn't win that one either, or copyrights, whatever it was. So I don't think that could work. But you're right. As they get more developed, people are not going to want, you know, with all respect to Cody, his basically rudimentary design. They'll want a professionally made grade gun. And I still think that the normal channels of commerce can facilitate that. But in terms of a gun that's not patented, there's no problem. But this is where the Baptist and Bootlegger problem comes in. On your 3D printer saying, don't print anything in the US patent database. Oh, and by the way, don't print anything that looks like a gun. That's a very easy logical step. But thank you for your question. Yes, in the back?
The professor brought up some very good points. The First Amendment's never been absolute, for at least a long time. Considered almost more of a privilege than a right, although there's some technicality on the semantics of that issue. But talking about whether we can work around patents and so forth in this kind of minutiae law, so to speak, the case that you're bringing to the appellate court and wherever that goes, the disposition probably would only bring it back to Congress saying, well, clearly we can work around these laws. Whatever happened in this case with the professor's comments and so forth and a plethora of case law, clearly Congress can make a very constitutional law, statutes supporting this and pretty much protecting. Again, not trying to choose up one argument or the other, but it seems like it'd be perfectly legal and constitutional to somehow prevent this from happening.
So the short answer is if the Court of Appeals or the Supreme Court holds that this data is protected by the First Amendment, then no statute could punish publishing information. And we cite a number of briefs in our case, a number of cases, the Pentagon Papers, among others, where the New York Times went to court. I'm sorry, the government went to the court and said, you have to stop the New York Times from publishing this newspaper article, the Pentagon Papers. These were documents about troop movements in the war in Vietnam. I mean, these were some pretty sensitive stuff. And the DOJ went to the Supreme Court. If you let them publish this, we'll have grave national security threats. And the court asked, well, what specifically? Like, well, we can't really tell you, but there'll be some really bad stuff will happen. And the Supreme Court ruled in favor of the New York Times. And I don't have the exact quote here. I think it was either Justice White or Justice Stewart. I'm blanking on which one. There were six seriatim opinions, or so many. I think it was either White or Stewart said, in order to justify prior restraint based on the harm that could result, you need to have a very specific, concrete harm, right? You can't just have a vague, generalized, nebulous threat that this speech will harm someone. That's something concrete. And I think Holder versus HLP has similar language. Here, if you read the government's brief in our case, they have very generally vague harms. They said it's possible that a foreign mercenary army could download these files and use it to assassinate a world leader. Okay, maybe, maybe not. But that doesn't come anywhere close to the standards the courts have held about whether prior restraint is justified. Now, Michael's point is directly on point. Is this speech, right? That's our threshold question, a question the district court decidedly did not want to resolve for clear reasons. Whether it's our case or otherwise, I think the court will eventually have to resolve this question. Let me give you an example of a recent case. Google, for example, right? Their search results, is that speech? Because technically speaking, well, if Google decides to list your company on page 1 and your company on page 5,000, that's a very big business decision. And I may decide to bring an unfair business claim against them, an antitrust claim, saying they're actually trying to suppress my business because they're being advertised with this company and they're punishing me. Google has actually asserted that they would raise the First Amendment as a defense of the antitrust claim. I mean, this has been litigated, although kind of pettered out for other reasons. So is Google's search results speech? I think the answer is yes and no. It's complicated. But Eugene Volokh has written on this. There's a pretty good argument that you have a First Amendment right to express information. But again, there are consequences. For example, exemption from FTC jurisdiction, exemption from antitrust laws, exemption from gun laws. So once you start saying speech is protected, code is protected speech, you have now a constitutional trump to any statute that Congress may pass. And again, I've written about this, I'm also litigating it, but I freely concede this is a question that has not been resolved, but will have to come up soon. Yes, sir.
So assuming that 3D printing becomes more widespread, the materials that can be used become better, becomes cheaper, and eventually you can print an automatic weapon.
Mm-hmm.
And assuming that America doesn't move radically to the right on guns and still believes in however many years that is that we don't want automatic weapons everywhere, what are the government's options to prevent the widespread dissemination of?
Right. So the short answer, and I'll answer this a little bit circular, but I'll get back to it. The short answer is once our technology gets to that state, no law would help. All law can do is punish after the fact. You can't punish before. Right? If some exactly right. Basically, your options at that point are restricting the raw materials, restricting gunpowder, and I don't think that there's much of an appetite for that. The reason why is even if they're able to go to the manufacturer of 3D printers and say, we want you to put this filter in, right? How many of you download illegal music before? How many of you downloaded on your Comcast account illegal movies? How many of you have ever hacked a phone to root it so you can put apps on it that Apple does not want you to have? So I mean, look, could Congress pass a statute requiring 3D manufacturers to put these filters? Of course. Will they be effective? No. So when we actually get to the point where it's that easy, I don't think arms control law will be very effective in any of that. So it's not directly answering your question, but I think that's more or less the world we'll live in. I mean, even manufacturers of items, the reason why Kanye West is so angry, right? Because he knows this technology will basically put an entire industry out of business. Yes, sir, in the back.
There's websites with information about how to make things like that shotgun pictures. And so that's not being requested to take that down.
Yeah, so this is what's interesting. So I'm glad you raised that. Cody put these files online shortly after the incident in Newtown, Connecticut. We have strong reason to believe that there was a serious freak out in the Obama administration. We got to do something about this guy. And they said, wait a minute, State Department, that's how we'll do it, right? That was like, how do we regulate this? What do we do? What do we do? Oh, State Department, got it, right? So the short answer is that no one else has been has been enforced under this provision, no one else. About 2 months ago, a guy put on the internet the files for making a 3D printed revolver, not a one-shot gun, a revolver, much more sophisticated than the Liberator. It's on YouTube, it's on everywhere, you can Google it everywhere. Not a single enforcement's been taken against him. So we have reason to believe that they freaked out and they did this and they tried to do something. This is not a particularly good fit for the State Department's jurisdiction. We don't think we think it's ultra virus with the statute, it's a different argument, but they don't go after anyone with this. This is not used ever, which is why it took Cody by total surprise. We also have a due process claim, right? Would a reasonable person think that this arms regulation law applies to putting files on the internet, right? Would you have noticed that this could be a prosecution? Of course not, right? A reasonable person would not think putting a file on the internet under, if you read the statute, would lead to this sort of result. I mean, the enforcement action, I think, there's a lot of ways we can win. We can win just on due process alone, which, you know, whatever, but there are a lot of different ways we can win this case. You want to ask a second question? Yeah.
Yeah, I just want to go back to this one. That's what it makes the weapon or legal, because in the anarchist code book, pipe bombs are illegal, right?
Yeah.
And you're still allowed to tell someone how to make money. So by that logic, shouldn't you also be allowed to tell someone how to make an illegal firearm?
So let me answer this question a couple ways. So first, I don't know that it makes a difference for the person transmitting the code, right? Because Cody's not the one making the pipe bomb. The second answer is that something called crime facilitating speech. Read Eugene Volok's article. It's really good on this. But the courts have been a little bit more skeptical of crime that facilitates illegal conduct. Okay, I'm sorry, speech that facilitates illegal conduct. They've been more skeptical of it. In our case, the reason why I think we actually have a fairly strong case is the very item that Cody's telling people to make is the quintessential weapon under Heller that's protected. So the Second Amendment actually bolsters our claim. The common example, I guess, what happens if you have the, you know, someone has instructions to make an atomic bomb or biological chemical weapons, right? The Supreme Court's also had a special series of case law on classified information, contrary to Mrs. Clinton, right? Generally speaking, there could be strict restriction on classified information, and the First Amendment doesn't really apply. There's state secret privileges and other things. But if there was a weapon that could be produced lawfully, I think the claim is stronger. Again, the facts of this case were forced by the government. I mean, they enforced, you know, this specific item, and that's what we're dealing with. We're not dealing with, you know, automatic weapons. We're not making the claim that's possible. Yes, sir.
Do you think there's anything to the distinction between additive and reductive construction?
You want to explain to your colleagues what that means?
Sure. So the idea is you can take a block of steel and mill it out and reduce
Mhm.
that into a gun, and that's okay. But 3D printing, adding on is
Thank you.
not okay.
So actually, there are two separate, not claims, but two separate items at issue. So Cody didn't just design a way to make guns using this, you know, spraying one layer on top of another. He also made something called a ghost gunner. Do you know what that is? Okay, so if I took a block of steel and I took a mill, you know, thing that drills, I could actually shape that block of steel into an AR-15 receiver. I am not skilled enough with a machine shop to do this. So what did Cody do? He created a device where if you put in a block of steel, it has a drill, and it automatically drills all the right holes and reduces it down into a fully functional AR-15 receiver. Cody wanted to transmit the code necessary to make this drill bit operate. And the government has taken the position that that code, too, is protected by ITAR. So that's another aspect of our case. We think that the code telling you, you know, move left like this, move right like this, drill here, drill there, is, excuse me, equivalent to the sorts of code being used in the additive method. But we think they're both in play. Cody's very creative like that. So, was your hand up?
So you think that no law can apply except the final application of it? The DM copyright law cannot apply until you actually use it as a final user. This law cannot apply even though a felon will use it to get a gun, which is currently acceptable restrictions under 2D, Second Amendment, etc. Right? The only person that applies to it is the final producer of the gun.
Right. So
everything else is speech.
Right. So the felon possession. Right. So I mean, I'll use an example. I publish a book on how to manufacture a firearm. A felon walks into a library and checks that book out, and he uses that book to then manufacture a firearm. I wouldn't think the person who wrote that handgun book liable for whatever crimes a person commits, and nor do I think the book would be censored. So yeah, I mean that's how I respond to that question. Yes, ma'am.
I have a question more in the bigger scope of security. What if you printed these 18 different parts of plastic and you put them in whatever suitcase or something? Would you be able to walk through any detector, and could that be like a problem that it's just easy to disguise the gun and then assemble it later?
Sure. So the short answer is plastic guns have existed long before Cody Wilson. There was a movie with Clint Eastwood. What was it called? Do you remember the name? was a Clint Eastwood movie in the 70s where they had a plastic gun. So I mean, this is going way back. The gun that Cody designed actually has a chunk of metal in the design to be put into the handle to actually set the metal detector, right? So as designed, the Liberator would trigger the metal detector. Could someone bring a plastic shiv to a metal detector, a plastic weapon? Yeah. Will TSA body scanners catch it? Probably not. So I don't have an answer short of saying that this has been a problem that's been around for a very long time. And being able to have, non-metal weapons through a metal detector is not limited to what we're talking about here. It would have to be fairly small. I imagine if you're trying to bring a rifle a plastic rifle in your carry-on bag, it would be fairly obvious. So thank you for the question. Good question. All right, we'll start again.
Yeah, no, could the government classify all of this? Could they constitutionally classify all of this information about guns if they? I mean, I don't know very much about national security law.
I think this is. Let me answer the question this way. Generally speaking, public speech that you create for publicity, is not going to be classified. Government speech is usually kept internal, so I don't think there's really a mechanism to classify public speech. There's actually also, if I can branch off, there's actually an academic argument here. Lots of academics put online information about cryptography, and universities need to go through extremely difficult hoops to even have their academics publish information on cryptography to be used as a weapon. This is very burdensome. We actually expected, because universities don't like guns, we expected amicus support from research departments, universities, saying that this is really burdensome for them. Yeah.
So the internet isn't just purely within the United States, and whatever I think that your First Amendment concerns are about dissemination of this information in the United States is pretty strong. But what do you have to say about the possibility that putting this kind of information online essentially allows your client to poke holes in the arms control regimes and laws and policies of other countries that might not have our values, don't have our constitutions, don't see the right to bear arms in the same way that we do, and essentially using the First Amendment and essentially opposing our view of content.
So let me ask you another question. If I created a website with Holocaust denial, and some person in Germany viewed that where it's actually a crime to deny the Holocaust, we are piercing their values. America, I don't care. I'm just being glibly, but the short answer is, even under Reed v. Conover and other cases, our constitutional rights travel with us wherever we go, right? Our constitutional rights don't end at the borders. If, for whatever reason, we put information on the internet, that country can use their censors. That country can use whatever methods of censorship they want. And the government's actually argued this in our case. They've actually said because of foreign security, we need to limit domestic speech. And I don't know any case that stands for that proposition. I mean, Pentagon Papers is the exact opposite. I mean, if you look at the Pentagon Papers case, publishing this article will harm our interests abroad. And the court said no. So, if someone in if another country wants to criminalize this, they can punish their own citizen speech, they can censor their own internet. But I don't think that's a, Missouri v. Holland notwithstanding, that doesn't give the president the power to do this. I'm actually waiting for a Missouri v. Holland argument where some international arms treaty makes the president have the power to censor our speech. Never made that argument yet, but I suspect it'll probably pop up at some point as we go up the game. I do not like Missouri v. Holland. Judge McConnell.
You said you were going to get back to your case, but I don't think you actually.
Oh, okay.
did. Could you just tell us what the precise
Yes, sir.
issues presented are?
Yes, sir. So the question we have in our case is back to this letter. Let me show you this letter. This letter was sent in May of 2013, and they effectively told Cody that he is not able. What time did we finish, Jonathan? 2. Okay. Oh, at time. Okay. So the State Department said to Cody, "You cannot publish these files on the internet." Okay, fine. What happened afterwards, what people don't even know, is that he took the file immediately. He actually complied with their order. And he submitted what's called a commodity jurisdiction request, where he basically said, I am seeking the government's prior approval, right? I want the government to approve that I post these files online. That request went unanswered for 2 years, okay? Shortly before the statute of limitations ran in 2015, we filed a preliminary injunction saying basically a couple things. First, you are censoring our speech, there's irreparable harm. Second, rule out our stupid requester, give us an answer. A week before the government's reply was due, they actually finally ruled on Cody's request, and they said, sorry, you can't do it. At the same time, the government proposed new rulemaking in the Federal Register saying that they want to codify this prior restraint into the CFR, the Code of Federal Regulations. So basically what they did to Cody, that's been somewhat vague authority, they said we want to codify this. So we brought a number of claims in federal district court. We brought a First Amendment claim saying censorship. We brought a Second Amendment claim. We brought a due process claim. This entire idea of having to submit a request and wait 2 years, if that, who knows how long, before getting a response. There's really no appeals process. There's really no due process. So there's that. There's also a vagueness claim because it's unclear what the statute even authorizes. We have an ultra vires claim. The 1974 Arms Control Export Act in no way suggests that the State Department has this sort of authority. It's meant to stop Stinger missiles to Afghanistan. That's what this law is designed to do. So we have these claims. In August, the district court ruled against us. I won't comment on his honor's opinion, except to say that I disagree with it. We filed our opening brief about a month ago in the Fifth Circuit. All of our briefs are online. I'd be happy to give you a link later. And we will vigorously prosecute this case all the way. Again, our lead counsel is Alan Gurr. He argued Heller McDonald. We have a guy named Matt Goldstein, who's an expert lawyer, and somewhere a law professor is tagging along, not quite sure why, but I'm very proud to represent this case. If you have any specific question of the case, I'd be happy to address it. That's an overview sketch. All right, other questions? Going once, going twice. Thank you all so much for your attention. I really appreciate it. Thank you so much. I'll stick around after you have any other questions. Come up and talk.